The crisis currently rocking the office of the Chief Justice of Nigeria has been described as a mockery of the country's judiciary system. This, however, is not the first case of attempt to remove a sitting chief judge around the world, but perhaps the first in Nigeria. A closer look at Section 292 of the 1999 Constitution. The CJN holds office at the pleasure of the Nigerian Constitution and can only be removed from office by death or on attainment of age 70. Whichever occurs first, or by impeachment by the Senate of the Federal Republic of Nigeria, which requires a supermajority of the members of the Nigerian Senate. In the United States, impeaching and removal of a federal judge, including a Supreme Court justice, requires a majority of the House to approve an indictment to impeach and a two-thirds majority of the U.S. Senate. What is the Chief Justice of Nigeria's offense? Failure to declare his assets just after resumption in 2005. Falsely declaring his asset prior to assuming his duties as the Chief Justice of Nigeria in 2017. Omission of 3 domiciliary accounts, pounds, dollar and euro account. Therefore, did Onogen's trial follow due process?
It appears that the tribunal does not have the jurisdiction to hear this case at this time, given that the court is clear on the law that before a judicial officer is subjected to criminal proceedings, that the matter first has to be referred to the National Judicial Council, which has not been done in this case.
For some legal practitioners, the CJN trial has been linked to next month's election, which will clear the way for the incumbent should there be an election petition.
The procedure, the due process is that a judge of the Federation of Nigeria must first be brought before the National Judicial Council before any action can be taken against that judge. In this instance, it didn't happen. So that in and of itself fails. Even if the federal government decides to take this judge, the Chief Judge of Nigeria, to the National Judicial Council, the other law that will hold them in a chokehold is that the ethical violation must have taken place 6 months, not more than 6 months, upon the report of the allegation.
However, the ruling or progressive Congress thinks otherwise.
That there is a political motive behind the allegation brought against the CJN might itself be indicative of some unholy alliances. The likely affinity existing between the PDP and a section of the judiciary is further accentuated by the non-appearance of the Justice Onogen before the Code of Conduct Tribunal on Monday.
While the trial lasts, Nigerians are in desperate need of an answer, while the authorities could bypass constitutional provisions in bringing the CJN to book. Itogi Moore, edit. Rootstv Nigeria.